Hello, everyone. Welcome to the third session of the NYU webinars entitled Contract Law for Arbitrators, Brazilian Law, New York Law, and Transnational Law. Today, we will discuss good faith. To debate such a relevant issue, it is my pleasure and honor to introduce you Eduardo Damião Gonçalves, partner of Matos Filho Advogados in São Paulo, Brazil, one of the major Brazilian law firms, and Eduardo himself, one of the most respected practitioners in the field of arbitration in our country and abroad. Eduardo also currently serves as Vice President of the ICC Court. Eduardo, it's a pleasure to have you with us today. I also have alongside with me Laurence Shore, Head of the International Arbitration Group of Bonelli Erede in Milan, Italy, and we will have the benefit to profit from his experience as a practitioner that has previously worked in law firms in London, New York, and Washington, D.C., and now in Italy. And he also serves quite frequently as an arbitrator in commercial and treaty arbitrations. And, as always, we are in the good company of Professor Franco Ferrari, with whom I have the honor to organize this series of webinars kindly hosted by the Center for Transnational Litigation, Arbitration, and Commercial Law of the New York University, with the support of Arbitration Channel, who is broadcasting this session of today. Once again, I would like to remind our qualified audience that they can use the chat mode to address any questions they wish to our speakers. I would like to encourage our colleagues to address any questions they may have at any point of our webinar. And today, unlike the other first two sessions, with the permission of my colleagues, and hoping not to abuse of my role as a moderator, I would like to say a few words regarding good faith before giving the floor to Eduardo, who will be our first speaker. As you know, good faith is usually presented as a major difference between civil law and common law. Indeed, it is quite frequently said that good faith is a major feature of civil law countries, whereas common law countries have an aversion to such legal doctrine. This view not only oversimplifies things, but critically, it is misleading. Although it is accurate to say that good faith plays some role in most civil law countries, that does not allow the conclusion that this doctrine has the same relevance on all of them. The consideration of the perhaps most influential countries of civil law, Germany and French, suffices to prove this point. On one side of the spectrum, German law is worldwide famous for the importance it attributes to good faith. Departing mainly from a laconic provision of 1900, the famous paragraph 242 of the German Civil Code, that basically says that contracts must be performed in accordance with good faith, German courts, with the major contribution of German scholars, developed several legal doctrines based on good faith. Namely, just to give you an example, following the footsteps of a book published in 1955, it is generally recognized that good faith has three different functions under German contract law. First, it has a creative function because it creates duties to the parties other than those that they have specifically agreed upon in their contract. Second, it has an interpretive function because it is a key criterion to interpret contracts, as we had seen in our first webinar. Third, it has a corrective function because it limits the exercise of rights that arise from a contract. In German law, good faith is also the basis of the rules regarding hardship, a topic that we have discussed in our last session. 100 years after the German Civil Code entered into force, some of the doctrines based on good faith were incorporated to its text, a fact that can be seen as the culmination of a long process that gives weight to this so-called general clause, as perhaps no other civil law country does. On the other side of the spectrum, French law is known for not giving so much weight to the doctrine of good faith. Compared to German law, and we're always in the realm of civil law, French law approach is historically remarkably different, despite the French code having a provision stating that contracts bind the parties not only by its wording, but also by what was required by good faith since 1804. That does not mean that French courts were oblivious to the legal questions that were solved by German courts with good faith. Of course not. Much to the contrary, it is far more accurate to say that French courts adopted other doctrines than good faith to deal with these same issues. 2 centuries after it entered into force, the French Civil Code was recently reformed. Since 2016, it has now a provision in line with the paragraph 242 of the German Civil Code, which is Article 1104, stating that contracts must be negotiated, executed, and performed in accordance with good faith. Critically, Article 1104 of the reformed French Civil Code also states that good faith is a matter of public policy, meaning that it cannot be waived by the parties. It is still for us to see whether this provision will lead French law to give more relevance to good faith than in the previous 200 years of the effectiveness of the French Civil Code of 1804. What I think it's quite interesting is to understand where Brazilian law stands between these two different approaches proposed by German law on one side and French law on the other side. Historically, both German law and French law have always been a major influence on Brazilian law, as quite often happens in civil law countries. In 1815, the Brazilian Commercial Code was approved. It was the first Brazilian code in the realm of private law. Although it contained a provision stating that contracts must be interpreted in accordance with good faith, such provision has not been developed over the years. Instead, it remained without any particular importance, much in line of what was happening in France. The first Brazilian Civil Code was from 1916. It has given very limited importance to good faith. In contract law, in particular, there was a single provision regarding good faith in the insurance contract. But again, it has not been developed over the years. Despite the lack of a general provision, in the decades of 1960 and more frequently in 1990, some scholars vigorously argued that good faith was a part of Brazilian civil law. Their writings were influential to some extent, and there were rulings based on good faith already during the effectiveness of the Civil Code of 1916. However, this was a view that was not shared by many, as the vast majority of practitioners did not attribute any special relevance to the doctrine of good faith by then. This has fundamentally changed with the Civil Code of 2002. Following the footsteps of German law, the Civil Code of 2002 expressly acknowledges the three functions of good faith. It appears as an interpretive criterion on Article 113, as a limit to the exercise of rights in Article 187, and as a source of duties on Article 422 of the Brazilian Civil Code. After the Civil Code of 2002 entered into force, good faith has experimented a relevance that was unknown until then by Brazilian law. The key question now is no longer whether good faith is a part of Brazilian law, of course it is, but how it should be applied. What is actually the actual relevance of good faith in Brazilian contract law? This is precisely the point that I would like to discuss with Eduardo Damião Gonçalves today after this introduction that hopefully was not too long. Eduardo, once again, thank you for accepting our invitation to join this webinar. I understand that you are abroad, so thank you for organizing yourself to participate today. And I would like to start by asking you to give your perspective of the role played by good faith in Brazil since the Civil Code of 2002 entered into force. How do you think that the approach of practitioners, in particular, towards good faith has evolved over the last 2 decades? Eduardo, thank you again. The floor is yours.
Thank you very much, Cristiano, and thank you, Franco, as well. And congratulations to all of you for this series of webinars. And it's always a pleasure to be anywhere with Larry. So great to be with you all here today. Well, I think you observed very well, Cristiano, in your introduction, that the notion of good faith already appeared, right, in our Brazilian system before the code of 2002, of our civil code of 2002, but in a very shy way, if I say so. And it appeared in a requirement of good faith in insurance contracts. It was expressly mentioned in the code of the consumer law as a parameter to assess the nullity of contractual clauses incompatible with good faith or equity. And by the way, I think that this reference to good faith in the context of consumer law has left some kind of memory that affected somehow how this was implemented later on in other contracts, and I will touch upon that in a minute. It was really, as you correctly stated, with the Code of 22 that good faith really, I think, achieved a major role in the Brazilian legal system, at least as something, and I think we all remember that this has caused a lot of attention from the moment that the code entered into force in 2003, exactly with those 3 expressions of good faith that we see and that you already mentioned, right? The good faith as an interpretation tool, good faith as a limit to the exercise of certain rights, and where you find different variations and expressions of this limitation to the exercise of rights, like the theories of abuse of right, and of course as a source of duty that is expressed in Article 422 of the Brazilian Civil Code. And I think that where you have a lot of expressions as well in the application in Brazil. But I mean, it is good faith is an open rule or an open principle, if we want to say so. It's obvious that practitioners would have to have a major role in the correct application of the principle in a case-by-case basis, right? And you could, I think, divide the approach of practitioners, and of course, we are thinking here at the same time lawyers applying and using it in their cases, and of course judges and arbitrators having to decide cases where parties have raised either defenses or theories on good faith. Practitioners, I think, have evolved over the 2 decades in 3 different moments, right? I think we had a first moment where there was, a lot of writing about it. Everybody, of course, making reference to the German origin of the principle and how it was being introduced in Brazil and the importance of it. So it was a moment of understanding the institute, trying to identify and learn its different functions that you so well, I think, mentioned in the introduction. A second moment is like I think it was the actual application by judges, scholars, and lawyers and arbitrators, and trying to, I think, to go a little bit deeper in trying to analyze the different forms in which good faith is expressed, the duties and effects of each of those functions of good faith. And then I think, we heard a lot about, I think, the concept of course, the lateral obligations that are related to good faith, as in comparison to the main obligations that are the party should perform under the agreement. And of course, I think we went a little bit more into different forms, like the duty to cooperate, about which we'll, I think, be able to talk a little bit more. Duty to inform, duty to keep, the confidentiality of information in the agreements. And then I think a moment that is the one that we are experiencing today, where I think we have already a set of cases in which I think we see where cases have been, unnecessarily applied or invoked by parties, or correctly applied. Uh, and I think the need to really to go a little bit more precisely on the definition of the criteria and how it should be applied in different scenarios. I think, in other words, in the last 2 decades, I think they have led us to a moment of refining good faith application in Brazil. Also, I think to avoid a sort of a skeptical view of its transforming potential, and also to enhance its importance in the resolution of concrete cases. And why I mention that? Because I think that the main point, I think, of good faith, and that's why I related in the beginning to consumer law, is that I think everybody, and I think both of us, right, you and I, were fortunate enough to practice before the civil code and after the civil code. So I think we could witness this 2 decades. And I believe in the beginning there was also a lot of skepticism, because I think there was a tendency to use good faith as a joker. I remember in some discussions in arbitral tribunals where I was, together with other arbitrators. That is, I mean, a very simplified way, but sometimes we saw in the beginning of the cases where good faith would be everywhere. It was most like you'd have a template of a brief with good faith, and then parties would build all the case around it. I mean, you wouldn't find a case, whatever the case was, where good faith would not be invoked somehow. And that sort of led to some kind of simplification, as I was saying, that too much, if you raise too much good faith, it's because the main obligation of the contract, the party you represent, is not very strong, or has not, complied with its obligations on the agreement. So I think there has been such a broad and sort of abusive way of good faith everywhere, that sometimes it was associated with lack of better arguments. But I think, of course, this has evolved. And when I think you analyze Brazilian cases applying good faith, and also I think looking now with the experience, of course, of something that we have not so available, which are arbitral decisions, I think there are very good decisions that duly apply good faith and implement its very varied functions appropriately and accordingly. But I still think that you will still verify some indiscriminate or confused way of the same functions. And I made the reference about the consumer law, because this, I think, raised a lot of concerns, and as you certainly, of course, know, but I don't know if our foreign colleagues know. Um, since I think the concept of good faith was somehow associated to an excessive interventionism of courts into private relations, uh, mainly because of this origin that predates the Code of Civil Procedure, that is related to consumer law, to a point that I think with I think deserved criticism. There has been a law that was passed 3 years ago, that is the so-called law of economic freedom, and it was passed actually to try to consolidate interpretation, or of I mean, it was, I think that the goal was really to try to reinforce the need to protect the freedom of the parties and their choices in the agreements, and to try to reduce the power of interventionism, mainly I think by judges when it was done at that time, on private relations. I think we can maybe discuss that a little bit later. I think I think among the ones that think it was maybe too early to do that, or it was unnecessary. It was an attempt to block interpretation of a concept that is a very varied concept, and I have a hard time understanding if really added a lot to the system. But I honestly don't know your opinion about it, and it will be good to have you again say something about it later on. So I agree with you entirely, Cristiano, when you said that the key question is no longer whether good faith is a part of Brazilian law, but how it should be applied, right? And this is not a simple answer. That's why I don't think that is going to be a law like the law of economic freedom that will that you will be able to regulate how the concept is applied. I think we have to have trust in our decision makers, be them judges and arbitrators, and I believe that 20 years, I think it's not a long period, and I think we are still in the process of building up this system. And I think there was a lot of tests to the good faith principle also during the pandemic, right, where I think we could see main attempts to try to use the COVID pandemic as an excuse to escape contractual obligations in many circumstances where it was not absolutely the case. And I think there, I think we saw, I think, courts and arbitral tribunals giving decisions that I think showed, I think, a very where I think the principle in its different forms had, I think, a very important role. But I think that when you look in the reflections of the practice in the three different in those 20 years, I think it's interesting to look at the different in the three expressions of the principle, right? First, probably on Article 113 of the it as an interpretation criteria, where this function is many times applied by practitioners or tried as an argument by lawyers. Sometimes when it's possible to see from the agreement itself what is the actual will of the parties. And sometimes, and that's, I think, an example of an abusive attempt to use good faith as an interpretation criteria, where a part tries to invoke it in order to depart from the party's main obligation. And I think when and I think this is an important thing, right? I think when the agreement is clear and the will of the parties is clear, good faith should not have an incidence and should not be used to try to deviate from, I think, the actual goal that the contract tries to achieve. Then I think you have, of course, the expression that we saw in Article 187, where good faith has a limit to the exercise of the rights. And there, I think we have a lack of technical rigidity when applying the different expressions and ramifications of abuse of rights. And then you see suppressio or venire contra factum proprium. I think everything mixed up, and again, sometimes in an improper way. And then I think, and I will finish by that, I think, of course, on Article 422 is where I think, and of course, as my experience is mostly in arbitration and in a specific kind of arbitration, I think I see it more there. So, the good faith oriented towards the fulfillment of the obligation and sets of rights that arise therefrom to guarantee the fulfillment of the main obligation, right? To fulfill the fundamental duties. And as I said, the expressions of good faith as lateral attached duties. And of course, I think that the duty to protect the agreement and the interest of the parties, privacy, duty to cooperate, and duty to inform, I think, are expressions that I think we see very, very commonly invoked and applied, of course, in support of the main obligation. But this is a discussion that I think it has become more and more frequent. Even though I think we have to agree I think the role of good faith here is a secondary role, right? I think, of course, and I sorry to state the obvious, but of course, it should maybe support the main obligation. But it's, I think, at least, I see tribunals and courts trying to avoid, at least, in contracts among sophisticated parties, to let to leave good faith as a leeway to interfere in the choice of the parties. But I mean, I think that in conclusion, there is still a lack of parameters, actually clear parameters on the implementation, and certainly there are still difficulties in assessing all the expressions of good faith, and that the duties of good faith are have or not are enough to affect the something that will change the main obligation of the contract. So long answer to this question about the users.
It was a long question as well, so it allows a long answer. If I may, I would say that trying to summarize what you just said, that we depart from a first period where there was a lot of enthusiasm regarding good faith, but a lack of precision. Now we do have less enthusiasm, perhaps a little bit more precision while dealing with good faith. And one thing that always comes to my mind is that the Romans used to say that nothing is more in accordance with good faith than to fulfill the contract. It's the utmost protection of good faith is to fulfill the contract. Of course, it's one aspect of good faith, it's not a single aspect, but it's quite neglected during perhaps the first period that you mentioned. And I agree with you. I think that the influence from consumer law has caused some damage to contract law in general. And perhaps this is one reason why we do have this so-called Economic Freedom Act. It's a bit odd. In my opinion, it does not add much. It's like saying that the rain is wet or the sun shines. It's quite obvious, but I remember an older professor once told me, sometimes we have to state the obvious. It's not always unnecessary. So I think it provides some help, but I entirely agree with you. It would not suffice to lead to a good application of good faith. Generally speaking, it's neutral from this point of view. It does not add much, does not cause any harm, but generally speaking, it's useful because it states the obvious, and sometimes people do not see what is obvious to most of us. So, if I may, I would like to come back later to the question regarding the duties. And right now, I'd like to move a little bit forward to ask Larry's perspective regarding common law. I would like to ask Larry, if I may, whether he understands that the approach towards good faith is not as uniform in the world of common law as one may think. I'm asking this because I'm under the impression that not all common law jurisdictions have this proverbial aversion to good faith. If I'm not mistaken, under New York law, which we'll discuss right now, it is generally recognized that, and I'm quoting here, all contracts imply a covenant of good faith and fair dealing in the course of performance. End of quote. Hensler, I would like to ask you, is it correct to conclude that good faith, perhaps some civil lawyers would not expect, is a part of New York law? Thank you for joining us. The floor is yours.
Thank you, Cristiano. Many thanks, of course, to Professor Ferrari as well. And I was intrigued by Eduardo's Brazilian law description because it doesn't sound quite so different, I think, from what I'll have to say. Good faith, to answer your question, Cristiano, is certainly a part of New York contract law. However, it is not a cornerstone. It exists on the boundaries. The covenant that you have quoted has typically been interpreted in a very limited way by New York courts, and I'll come back to that with you, I think, in a few minutes. But let me first describe the contours of the covenant as expressed in a well-known New York Court of Appeals case from 2002 called Jennifer Realty, which usefully collects New York cases on the covenant since 1933 and includes at the outset of its discussion the sentence that you quoted. In New York, all contracts imply a covenant of good faith and fair dealing in the course of performance. And we can discuss a bit later the significance of in the course of performance, which notably assumes a concluded contract. The judgment in Jennifer Realty continues by explaining that the covenant embraces a pledge that neither party shall do anything which will have the effect of destroying or injuring the right of the other party to receive, the fruits of the contract. The fruits of the contract is, of course, quite vague. A key qualification from the court, New York's highest court, then follows. The duties of good faith and fair dealing do not imply obligations inconsistent with contractual terms. And I'll come back to that because that's a key phrase in the holding. The duties do encompass any promises that a reasonable person in the position of the promisee would be justified in understanding were included. And recently, in 2020, an intermediate appellate division added that the covenant is breached when a party acts in a manner that, although not expressly forbidden by any contractual provision, would deprive the other party of the right to receive the benefits under their agreement. That is to say, the fruits of the agreement. So, what are the implications of this general guidance from the courts on what the implied covenant means? And here are two that I would specify just right now. To plead a cause of action under New York law for breach of contract based on the covenant sufficient to survive dismissal, that is to say, sufficient to state a claim for breach of contract based on the covenant, the claimant must plead that the respondent failed to exercise good faith and deal fairly in fulfilling the terms and promises contemplated by the contract. But here's the second implication that I wanted to identify at the outset. If a complaint under New York law alleges both breach of the covenant and breach of contract based on the same facts and seeking the same relief, the covenant claim will be dismissed as redundant. In that respect, it can't be a separate cause of action. So it is a curious general circumstance in the way I think that Eduardo has described under Brazilian law. It's there. There's, I think, quite a bit of confusion amongst New York lawyers, New York judges, arbitrators applying New York law about how the contours can be specifically identified and then stated. It's clear that the covenant cannot create additional inconsistent obligations or nullify express terms of the contract. But absent those general propositions stated in the Jennifer Realty case, it is there's quite a bit of uncertainty.
I guess we could say that both in common law and civil law, the real question is the actual role of good faith. And you mentioned a point that I think it's very important, and what has been already raised by Eduardo before. Because at some point, people think there is a conflict between freedom of contract and good faith. That does not appear to be the case in New York law, and I would say that's not the case in Brazilian law as well. Because if you see, one of the roles of the good faith is to create duties in order to fulfill the contract. So it is quite easy to understand why it's very odd an allegation to say that good faith somehow deprives the party to the duty to perform the main obligations of the contract. It does not make any sense if you think of good faith historically. I would say it's not its role. It could sometimes be used to as a tool to limit the exercise of rights. It's a different issue, and we'll come back to that later. But the fact that good faith and freedom of contract are not colliding with each other, I think it's something that perhaps should be recognized more often. Because when you read what I just said, and you mentioned the decisions, it's not very different of what we have in Brazilian law, because our civil code states that good faith must be observed while performing the contract. And that's pretty much the same that we see in the German civil code, which is the major source of influence, at least in the world of civil law. So what I would like to ask to you, and perhaps later on we can come back to some more concrete discussions regarding the duties that comes from the good faith, is if you think that, and that what you said about being redundant, you say you have to fulfill your obligation, then you have to observe good faith. It's pretty much the same. But would it be accurate to say that under the perspective of New York law, good faith is there mostly to support freedom of contract? Is that too much to say? It's a too strong a statement? It's misleading? What do you understand of it?
So I would say that's a very reasonable way of putting it, Cristiano. That the covenant exists, and since it's vague in its description, as Eduardo, I think, mentioned, it's prompted many claimants to invoke it almost always, and almost as a Hail Mary kind of desperation pass if there's lack of adequate strength on the express terms of the contract in alleging breach. But I think New York courts, along the lines that you've mentioned, are really loath to make rulings that vary the terms that the parties have agreed. And if the conduct does not breach those terms, winning on an additional implied duty is a very heavy burden because of the freedom of contract. And I think also Eduardo mentioned, especially freedom of contract amongst sophisticated parties, many of which in major international arbitration cases that you would see. So one example I thought I would mention along these lines is sole discretion clauses, which I think gets exactly to the point that you're making, Cristiano. So parties do have the freedom to enter into, for example, a sole discretion clause. That is a clause that gives one side the discretion to sole discretion to act in a certain way under the contract. So the question is, can the sole discretion clause be breached by the exercise of discretion in bad faith? And the answer is generally your freedom of contract answer under recent New York cases from 2016, 2017, which state that a limitation, for example, on the exercise of a sole discretion clause, a good faith limitation, would in effect add a term to the contract. And therefore, the courts have been, and I think arbitral tribunals in those circumstances are unwilling to say that the fruits of the contract actually make are somehow different from the determination that the parties already made to enter into a sole discretion clause. So motivation, therefore, becomes irrelevant. And in that sense, I think New York law is quite much closer to French law on good faith than German law in the way that you described it in your introductory remarks. And in fact, I thought it was interesting that you mentioned 11 1904 and good faith as a matter of public policy, because then in the new French contract law reform, Article 1192 states clear and unambiguous terms are not subject to interpretation, as doing so risks their distortion. And that really is your point about freedom of contract and how it aligns with good faith, because even though the covenant is there under New York law contract law is a textualist jurisdiction. And like 1192, if the terms are clear and unambiguous, the covenant really doesn't have much of a role. It really does exist on the boundaries. That is not to say that you can't win if you plead the covenant, implied covenant of good faith and fair dealing. That's not to say that some New York courts, there's a very recent case called Rebecca Broadway in this line, along this line, states that as a backup, if the party didn't breach the express terms of the contract, it breached the covenant. And that's what, of course, claimants are always hoping for, isn't it? That backup of the implied covenant. It's just that it's a fairly uncertain backup, because it's a fairly uncertain covenant under New York law, because the textualist approach still defines New York law. And unlike the description you gave, I think the very intriguing one of German code, additional duties cannot be implied by the implied covenant of good faith and fair dealing under New York law.
Thank you, Larry. It's a fascinating issue because we think it's far more obvious than it actually is. It's similarities, but differences that are important as well. I would like to move forward to talk a little bit about transnational law. And I would like to ask Franco a question regarding the CISG. It has this famous, I would say, Article 7.1, stating that, and I quote, "The observance of good faith in international trade," end of quote, "is one of the goals of the convention." And this is a formula that perhaps we should discuss a little bit, because what then should we understand as good faith in international trade? Is this a different good faith? Is the good faith of German law, French law, New York law? None of that. So I'm curious to hear you about this. And at the end, the question is always the same. What is the actual role of good faith within the framework of the CISG? Professor Ferrari, floor is yours.
No, thank you very much for giving me the floor. And the issue is, in fact, the one you mentioned. Why? Because there is a dispute both in legal writing and in case law as to the exact role good faith may play under the CISG. Now, this is due to the fact, Cristiano, which you mentioned, meaning that the CISG refers to the concept of good faith only in Article 7, the CISG's provision on interpretation of the convention. Now, in effect, and let me tell you what Article 7.1 specifically says. Pursuant to Article 7.1, in the interpretation of this convention, regard is to be had, as we all know, to its international character and the need to promote uniformity in its application and now it comes, the observance of good faith in international trade. Now, clearly, this provision does not impose any obligation on the parties to act in good faith at any stage of the transactions. This should be very clear, but merely requires the interpreters to take good faith into account when constructing the provisions of the convention themselves. In this respect, Article 7.1 mirrors Article 31.1 of the 1969 Vienna Law of Treaties, which expressly refers to good faith when requiring that a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty. And here I'm, of course, remembering it, I think, correctly in their context and in the light of its object and purpose. Now, in light of this, one must wonder whether good faith is merely a factor to be taken into consideration in the interpretation of the CISG, or whether it may have an impact also on, and this is the issue, the rights and obligations of the party. Now, to answer this question, one has to look elsewhere, in my opinion, because as mentioned, Article 7.1 does not impose itself any good faith obligation on the parties, neither during the formation process nor during the performance of the contract. Now, the one provision courts and commentators have resorted to in order to impose certain good faith obligations upon the parties is a different one, namely Article 7.2, the CISG's provision dealing with the fact that despite statements to the contrary, I have to admit, the CISG is not a comprehensive code exhaustively dealing with all problems that may arise from international sales contracts. Now, in other words, the CISG does not provide solutions for all the problems that can originate from contracts for the international sale of goods. Now, this can be easily derived from the CISG itself. Just look at Articles 4 and 5 of the CISG, expressly excluding some issues from the CISG scope of application. Just to give a few examples, the validity of the contract or of any of its provisions or of any usage. The effect which the contract may have on the property in the goods sold, and of course, Article 5, the liability of the seller for death or personal injury caused by the goods to any person. Now, the CISG's limited scope of application gives rise to problems on how to deal with the CISG's incompleteness, so to speak. And it is to deal with this problem that Article 7.2 provides that, and here I'm quoting, questions concerning matters governed by this convention, which are not expressly settled in it, are to be settled in conformity with the general principles on which it, the convention, is based, or in the absence of such principles, in conformity with the law applicable by virtue of the rules of private international law, unquote, of course. But also Article 7.2 addresses an issue different from the one addressed in Article 7.1 interpretation. Both provisions, in my opinion, pursue a similar goal. They both attempt to ensure the uniformity sought by the drafters of the CISG. Now, to reach these goals, courts should, not only when interpreting the CISG's text, but also when filling gaps as much as possible, refrain from resorting to domestic laws and to try to find a solution within the CISG itself. Now, this approach, pursuant to which courts should try to solve issues from within the CISG, from within the convention, does, however, not apply indiscriminately. And this is relevant, even in the good faith context. Specifically, it does not apply with respect to matters excluded from the CISG scope of application, such as the one I referred to earlier when referring to Article 4 and 5 of the CISG. In other words, where there is an external gap, the ones I mentioned earlier, where an issue is not at all governed by the CISG, it has to be filled in conformity with the law applicable by virtue of the rules of private international law, or, of course, where applicable, with other uniform substantive law conventions. And here I'm referring, of course, to the 1974 UNCITRAL Convention on the limitation period in the international sale of goods, UNCITRAL's firstborn. But matters that are governed by the CISG but not expressly settled in it, meaning the so-called internal gaps, should instead be resolved in conformity, first with the general principles on which the CISG is based, and only absent such general principles, in conformity with the law applicable by virtue of the rules of private international. Now, this is, of course, the context. Why all of this premise? In order to get to how to fill these internal gaps, To fill these internal gaps, the drafters have therefore advocated an approach that combines recourse to general principles with recourse as ultima ratio, of course, to the rules of private international law. A choice that, in my opinion, demonstrates awareness by the drafters that absolute independence from domestic law is actually unreachable. Now, as far as the general principles themselves are concerned, of course, while there are some that can be identified more easily, since they are underlying one or more specific provisions, there are others, the identification of which is more difficult and therefore in question. Now, as for the first category, the most important principle is one just mentioned now by all of you, the principle pertaining to party autonomy. In effect, the wide autonomy parties enjoy under the CISG by virtue of Article 6 of the CISG itself confers dispositive nature to the CISG and thus leads to the rules of the CISG merely being default rules. At the same time, Article 6 is evidence of the primary role party autonomy plays under the CISG. What does it mean? It means, inter alia, that where there is a conflict, and you have also addressed this, where there is a conflict between the general principle of party autonomy and any other general principle, including the one on good faith, which I've been talking about, the former always prevails. Now, according to most courts and commentators, and here we get to the gist, another of these general principles is that of good faith. Still, this principle is generally considered, and this is something Eduardo also hinted at, to be too vague to serve any practical purpose, which has led to the identification of general principles that can be actually traced back to that of good faith, but which have a, so to speak, narrower scope and may be of more use in practice. Among these general principles are that, mentioned also by Eduardo, of the prohibition of venire contra factum proprium, as well as that of estoppel, which can be derived, actually, the latter one, estoppel, from specific provisions of the CISG, such as Article 16.2 and Article 29.2. And let's add another one, the general principle pursuant to which parties are required, and Eduardo mentions this as well, to cooperate with each other. This means, inter alia, to just give one example, that parties have to exchange information relevant for the performance of their respective obligations. Although, of course, only following and not prior to, of course, the conclusion of the contract, and provided that the duty to disclose information should not somehow prove unreasonably burdensome to actually the disclosing party, of course. Now, what does this mean? A party has to disclose, for example, to the other party, changes regarding its banking information, so as to allow the other party to effect payments it owes on the basis of the applicable law or the contract. But it is in this context, in the context of filling the CISG's internal gaps, in my opinion, that the good faith principle, as well as its narrower manifestation, so to speak, may play a role, if at all. This means that where the CISG provides a given solution, meaning where the CISG does not have an internal gap, resort to the general principle of good faith is not to be had. This would clearly, in my opinion, violate, or doing otherwise, would violate the CISG's architecture as well as the text of Article 7. This is also, for example, why a decision by the Hamburg Court of Appeal has to be criticized. Now, what happened? According to this decision, a notice of avoidance of contracts in case of fundamental breach, which is required under Article 26, is apparently not necessary if the insistence upon such notice were to conflict with the good faith principle. Now, this statement is simply wrong. The Hamburg Court of Appeal introduced an exception to the notice requirement that the CSG does not at all allow for. Just read Article 26. Not only, it did so on the basis of a general principle that, in my opinion, cannot at all be applicable in the context in which the Hamburg Court of Appeal did apply it. Why? Because there is an express rule, there is no gap in the CSG. Now, this means, and I'm concluding this part, of course, that the good faith principle in the CSG context has a very limited role to play. One cannot read a given domestic law's understanding of the role of good faith into the CSG, whether it is 245 is the German Civil Code or even other different versions. Thank you.
Thank you, Franco. This is very interesting, and I think it's a temptation to avoid, because sometimes courts, while applying different laws, they use the framework of their domestic laws. It happens quite often, and some courts are more criticized than others for doing that. But I would say it's a phenomenon that we see quite often, because they're used to think in a certain way, and then my law is the law. It's not the right approach, of course. I would like to dwell in two topics that we have, three of you have mentioned, and I mentioned those topics as well during my introduction. First one will be the creation of duties from arising from good faith, and I understand there's different perspectives from the three laws that have been discussing today. And then I'd like to ask a couple more questions regarding the role of the good faith while limiting the exercise of rights. So my first question regards the creation of duties. If I understood correctly, Eduardo was mentioning in his presentation that and in his experience in Brazilian law, the role of good faith while creating duties has been an important one in the world of arbitration. Meaning, if I recall correctly, regarding, for example, duty to cooperate, duty to inform. Eduardo was telling us that the discussions in arbitrations have been quite sophisticated on these two issues. And I would like to hear you a bit more on that, Edu, because I want to know from your experience if you think that those issues have actually been appropriately been discussed and they're far more precise than in the first phase of the adoption of good faith in Brazil that you also mentioned. Eduardo, please, the floor is yours.
Thank you again, Cristiano. Yes, I'm an optimistic by nature. So but I think by experience and observation, I think I've been able to see, and I think you as well. I think we departed from that one time fits all use of good faith, where you'd see good faith in every corner of any brief. I think to more specific use on, or really, I think as I think they attached lateral duties that are in support of the performance of the contractual program. Of the I think in support of the fulfillment of the agreement of the parties. And I do believe that there has been I think I think Franco mentioned it again just now, I think in relation to one that I think has been I think very much discussed, which is the duty to cooperate. I think I think there are different expressions that we see in this duty to cooperate, where that go beyond the simple look into each party's obligations as if they were separate obligations, where the non-fulfillment of an obligation by a party could not no longer be looked, at least in a few cases that I have seen, could not be seen without looking at the behavior of the party throughout the whole agreement. And of course, those things tend to, and I think the the longer is the time to perform an agreement, the higher is the chance that you will find good faith discussion in a dispute arising of that agreement. And I think you see that a lot in construction cases, and I think you see that a lot in M&A cases, because you do have as you know, an M&A, of course, for I think a construction case, it's obvious, but even for an M&A case where you have a share purchase agreement, I think the parties remain attached to that agreement. There are obligations that shed light to the years after that, and sometimes even to the period between signing and closing of an agreement. So I think there are many examples where you see the principle of good faith coming to look at the behavior of the parties. Sometimes, for an example, where one of the parties has not allegedly complied with its obligation under the share purchase agreement, that therefore would lead to a non-closing of the transaction, but this has to be analyzed together with the behavior of the other party and how or not this party contributed to the fulfillment of that obligation. You see that sometimes in construction and service rendering agreements, as well as you have a phase that depends on one party, and payments would only come after that first phase. For instance, an executive project is complete. Then, if the executive project is not complete, a party that was entitled to a payment after the executive project would have been completed, one would say, no, the contract was clear, but that party should not be entitled to a payment because the contract was clear. But when you look that it was the party that was had the obligation to pay that actually had a direct attitude and behavior that did not allow the executive project to be completed, then that party can be held responsible. I think the duty to cooperate, and I think we could go to the duty to inform as well, but I don't want to hijack the floor again. So I think the duty of cooperate is something that I see being developed a lot in construction and M&A agreements, and I think it's something that you see much more complex discussions, and not discussions replacing the performance or the main obligation of the contract, but actually I think we in view of fulfilling the obligation of the parties, or aiming at completing the contractual program that the parties had originally agreed upon.
Thank you, Eduardo. You're never hijacking the floor. You're contributing to our discussion. Do not worry about that. This is a fascinating topic regarding long-term contracts, because long-term contracts, perhaps we could say that they're always a bit optimistic about the future, because it's very hard to plan everything ahead for a 20 years or 30 years contract, as we sometimes see in practice. And even for a major construction project of 5 or 6 years, a lot of things happen during the fulfillment of the contract. And I think the problems that are raised by such contracts are common for all jurisdictions. Perhaps from a legal point of view, the question is how we deal with them. Perhaps we should understand we could deal with those problems differently. So I gather from your impression, for your presentation, that's my impression as well, that good faith could play a very important role while helping us in Brazil to deal with this kind of disputes in the realm of long-term contracts. But I'm curious to know how New York law deals with the same issue, because if I'm not mistaken, I think that I heard Larry say that good faith could not create duties under New York law. It's a covenant that's a different role, but still you do have the same problem. You inevitably gaps will arise. And sometimes the contract is not suffice in order to solve an issue between the parties. Of course, I think we have already established that. If the contract is clear, that's what it is. You have to fulfill the contract. But sometimes it's not. And sometimes, specifically in long-term contracts, you actually face some situations that are slightly outside the contractual program. So my question to you, Larry, will be then, do you think that good faith could play any role on this under New York law? And if not, how do you deal with these issues that inevitably arise in all jurisdictions?
Thanks, Cristiano. I do think in this respect, New York law is more restrictive, and there's less of a role, certainly less of an explicit role for the implied covenant of good faith and fair dealing. It is the case that the covenant cannot create additional inconsistent obligations. It could arguably come into play in a long-term contract where the terms somehow no longer fit. And I think then certainly what I see arbitrators do in applying New York law is trying to assess which party has acted more reasonably in the face of factual or legal uncertainty. And that certainly is what I think a New York law perspective will be. But I think bringing directly, for example, a duty to cooperate in or a duty to inform that's not directly linked to a term in the contract and an obligation of one party versus the other is something that would not be a usual New York pleading or decisional approach. And I think that is because it will be because it is not the implied covenant is not a cornerstone, and therefore you're still looking to try to fit into what the terms are. Now, there can be contracts under New York law that are cooperation contracts, and then you are definitely looking at which party is being more reasonable in the face of factual or legal uncertainty because all terms haven't been able to be specified. But in that context, New York law is looking at context. That is to say, it's looking to interpret the provision of the contract rather than going to some idealized notion that the parties have a duty to cooperate or that good faith applies. In those circumstances, then you're looking at the typical concerns about extrinsic evidence. What can we do to understand what a reasonable third party would have had in mind in the operation of this contract? I think what some arbitrators maybe try to do who aren't New York law trained is that they impose their perspective on what is reasonable or what would have been reasonable for the parties to have agreed without looking at the extrinsic evidence. And then I think there is a clash of legal cultures there. And I do find that sometimes happens, and you sense that New York law arbitrators are still trying to get back to how can I reasonably interpret this provision rather than and what people at the time would have understood was a reasonable interpretation of this provision rather than, well, the parties should cooperate in good faith. That is not the approach of New York law, even under long-term contracts. You still want to try to figure out what they meant when they entered into the contract, not really looking at their behavior. So I would just add that because we touched on at the beginning in the quote you gave, Cristiano, in terms of negotiating contracts, there's no concept, for example, of culpa in contrahendo under New York law. That just does not exist. Until you have a contract, unless you're going to plead fraudulent inducement or some sort of misrepresentation, you're not getting to good faith. A duty to inform, for example, in an M&A context. You need that concluded contract under New York law.
This is the beauty of comparison, I would say, because when you see the difference of quite important, but you have to dwell on it in order to understand what the differences are. Because in some institutes, difference is striking. For example, we do have culpa and contrahendo in Brazilian law and German law, and we do not have that in New York law. Instead, we're not talking about the fulfillment of the contracts, more commonality between New York law and Brazilian law. So what I just tried to emphasize at the beginning seems to be correct. It's a more sophisticated comparison than simply saying, "Oh, we'll have a complete aversion to that," or we adopt a good faith to everything. It's far more complex and then far more interesting than that. And I was wondering whether following the path of reasonableness, you will reach different solutions, concrete solutions in cases, whereas in the same cases where you should use good faith. I would be curious, this is a hypothetical question, of course, whether we would reach different results using different methods or whether such results will be quite similar. But that's a question for perhaps another webinar. And now I'd like to give the floor again to Franco, because I have a question regarding UNIDROIT principles. We know that UNIDROIT principles had been somehow improved in order to deal with long-term contracts. And it's to be discussed whether the intervention in UNIDROIT principles suffices to deal with these type of contracts. They're very complex, very hard to deal with. So I would like to hear you about the UNIDROIT principles. Are they more optimistic regarding good faith? Is this intervention concerning long-term contracts good enough in order to solve the problems that we have to deal with in our legal domestic systems? Please enlighten us a little bit about the UNIDROIT principles, a different transnational law, but quite interesting from our perspective. I'm afraid you're on mute, Franco.
Sorry for that. So allow me to say from the start that the UNIDROIT principles are quite different, not only in how they deal with good faith, but also in their nature. And this is an issue which I will address in a second. In their nature, what do I mean? While the CISG is also hard law as part of the law of 96 contracting states, UNIDROIT principles are not. So how do you get to the UNIDROIT principle, and why do I say it in this context? You get to the UNIDROIT principles normally when the parties choose the UNIDROIT principles. Why is it relevant for this purpose? Because it touches upon, Cristiano, what you referred to earlier. It touches upon the relationship between party autonomy and UNIDROIT principles. The hypothetical is the following one. You and I agree on the UNIDROIT principles too. Now look at Article 1.7 of the UNIDROIT principle, which is one of the various provisions dealing with good faith. Because unlike the CISG, which doesn't deal with it, if not in a very limited context, Article 1.7 states that each party must act in accordance with good faith and fair dealing in international trade. So here you have one of the most important provisions outlining a duty to act in good faith. Why do I say that when I also refer to, Cristiano, what you did refer to party autonomy? Because Article 1.72 states expressly, the parties may not exclude or limit this duty. So here you see right away how much emphasis is given to the duty of good faith. And even in this context, meaning where the UNIDROIT principles have to be opted in, the parties can apparently then not disregard Article 1.7.2. That, from a contract law point of view, is a little strange, I have to say. But courts have actually applied this provision. Actually, there is a decision by a court from Quebec, and it is the Superior Court of the province of Quebec, District of Montreal. It is from August 2005. Why do I refer to that? Because there, the court has actually pointed out that such duties of good faith and loyalty were obligations of public order under the applicable that cannot be excluded by agreement between the parties. And in that context, the court referred to a commentator who, in support of his statement that general principles of loyalty and good faith are of public order, which cannot be excluded, referred expressly to Article 1.7 of the UNIDROIT Principles. But Article 1.7 is not the only provision which refers to good faith. The UNIDROIT Principle also refer to bad faith. Here I want to say that the absence of good faith is not bad faith. Okay, that should be very clear. Reference was made to Culpa and contrahendo by Larry. Article 2.1.15 refers to negotiations in bad faith. I will not refer to that. But there are other provisions in the UNIDROIT principles that refer to good faith. For example, when reference is made in Article 4.8 to supplying an omitted term, reference is made there to the fact that where the parties to the contract have not agreed with respect to a term which is important for determination of their rights and duties, a term which is appropriate in the circumstances shall be supplied. Great. Article 4.82 says, in determining what is an appropriate term, regard shall be had among others, and then it also lists under C, good faith and fair dealing. Reference is made to, in Article 5.12, where implied obligations stem from, and expressly in Article 5.1.2c, reference is once again made to good faith and fair dealing. You did refer, Eduardo, to something that, in my opinion, is also somehow addressed in Article 5.3.3 of the UNIDROIT Principles, meaning interference with fulfillment of conditions. There as well, good faith is referred to as something you have to actually employ to consider condition fulfilled or not, and so forth. So you see here that the UNIDROIT Principles give much more weight, accord a much more important role to the doctrine of good faith than certainly the CISG, but I would also say a lot of domestic laws.
And speaking about the UNIDROIT Principles, one of the perhaps most popular applications of good faith is the so-called Venire contra factum proprium. I understand it's somehow addressed by the UNIDROIT Principles. I would like to ask you, whether you think that Venire contra factum proprium is not only a success of the public, but also a success of the critics. What I'm trying to ask you is whether you think that has been correctly applied by courts in general while using UNIDROIT Principles. And if you want to go on, you could also comment that regarding the CISG, because as I said, it's very popular. It has been, at least in my experience, has been invoked quite often. And then the real question is whether it has been invoked and applied properly. What is your take on that, Franco?
Certainly. If you look at the UNIDROIT Principles, I would say it may well have been applied properly, the doctrine of Venire, the prohibition of Venire contra factum proprium. I'm not saying no. In the context of the UNIDROIT Principles, maybe yes. Okay, so I'm not disputing that. What I would dispute is the excessive use in other international instruments like the CISG of references, for example, to case law dealing with the UNIDROIT Principle with very similar provisions, even if the CISG does not somehow espouse those same general principles and so forth. So let's be serious. There are general principles of the CISG or under the principles under the UNIDROIT that are not general principles under CISG. So there may well be a conflict. This is where I see the only problem. So not if you apply the UNIDROIT principles as they should, if they are applicable, nor applying the CISG as you should apply the CISG, but the problem I have is with reading UNIDROIT principles as general principles under Article 7.2, which I mentioned earlier. That is the most important issue, that is a risk, and it has happened. You have talked about long-term contracts. Now, we have talked about it before. Whether hardship is covered by the CISG is an issue we may have a different view on. But what you cannot do if you consider it covered by the CISG is somehow import the UNIDROIT principles as a way to somehow identify the consequences of such. So that is what I have a problem with. Not the single text, they may well be applied correctly, but when, unfortunately, for the wrong reasons, one text is read in light of the other.
Yes, different laws, different solutions, quite often. Eduardo, how about Brazilian law? Do you think that venire contra factum proprium has been correctly invoked, correctly applied? Has been venire contra factum proprium recognized? The prohibition, as Franco mentioned, of venire contra factum proprium has been recognized in arbitrations that you have been involved with? Please illustrate to us with your experience.
Thank you. No, I think certainly it's the most popular of the expressions of good faith in terms of limitation to abuse of a right. So it is invoked very, very often. It's, I mean, maybe the public here will not learn anything about that, but I find it interesting that once you start discussing a case with a client, there's somebody in the room that jumps and says, "Oh, it's venire." I think every single case when we're in the assessment phase, somebody sees something that can be invoked as venire. So, I mean, it is a success of public. As you correctly stated it, I think it's less so a success of critics or of decision makers. Even though I think it's, I think it's a very important. I think we have a case that you know well on the educational side. I think it's a very scholar expression of venire. You know it. It's a case of a franchise, or sort of a franchise with a school of a certain system, where the owner of the trade and the franchisor actually sends a letter at the end of a year to the school stating, "Oh, here is the everything that we have to organize for next year. Here's the prices that you're going to organize for next year." And the contract provided for a very simple resiliation clause, termination clause, that was more beneficial actually to the franchisor than to the franchisee, than to the school. And a few weeks after this letter stating, organizing the next year and all of that, so the franchisor changed their mind and actually decided to use the resiliation clause in the agreement, which was clear. They had the right to use that clause, but that there was a decision of Brazilian courts that actually understood that even if the resiliation was in accordance to the agreement, or the termination of the agreement was in accordance with the agreement, there was contradictory behavior that actually should entitle the franchisee to indemnification due to having been led to believe that the following year there would be an extension of the agreement. In arbitration, to be honest, at least in my experience, I've seen it used as like in supporting role, but never as the main point to take a decision. And I see this like in an accessory way than actually, at least in my experience, a decision where the main ground for the decision was the principle of the prohibition against venire contra factum proprium.
It's that I had the same experience. It has been alleged a lot, not recognized very often, because it's a high threshold to meet always, and it's a way of controlling the exercise of rights, not the right itself. Because usually the party who has the right is the party who has the advantage in the case. So it's hard to argue against the right. You have to demonstrate a lot of requirements, and Article 187 is quite strict on that. So despite its popularity, there's still a long way to go to become somehow a movie star of the world of civil law. But there are cases, and sometimes it's the proper way to do with them. And and you just gave us an example, and I'm aware of this case. I think it's has been decided correctly, granting damages to the party that was somehow surprised by the disloyal behavior of another. That's one of the main reasons why we do have this doctrine in our civil code. But these problems are not typical of Brazilian law nor of transnational law. This kind of behavior is everywhere. So perhaps what we should ask is, how do we deal with that? And I'm under the impression, obviously not qualified to speak about New York law, but I'm under the impression that New York law has a different approach to that, because New York law has different figure, different doctrine, which is called estoppel. And I have read some essays, some papers, and I'm always under the impression that estoppel and venire contra factum proprium, they share some similarities, not the same, but not entirely different. So before giving the floor to Professor Ferrari to close the session, I would like to ask Larry to briefly talk a little bit about estoppel to see whether can we actually compare it to venire contra factum proprium, or I could be entirely wrong, it's completely different. So I'd like to learn from you whether I'm making a correct assumption or a wrong one.
I think it's a correct assumption, Cristiano. It is equitable estoppel. So there are different types, right? There's promissory estoppel, equitable estoppel, collateral estoppel. But if we focus on equitable estoppel, because I think that's probably closest to the Venire doctrine, I agree with you. There are maybe some differences. That the root of it in New York and common law is not good faith, but actually fairness, which I think is distinguishable from good faith. That is to say, the application of the estoppel or equitable estoppel doctrine under New York law requires only justifiable reliance and prejudice. The focus is more on what's happened to the party that has justifiably relied on the opposing party's actions and has been misled into a detrimental change of position. It's not a focus on the lack of good faith on the party that is setting himself under the Venire doctrine in contradiction to his own previous conduct. It's more the focus on reliance and prejudice. It doesn't require the existence of an intent to deceive. It doesn't require the existence of bad faith. It doesn't require the existence of fraud. It nonetheless is often difficult to show under New York law because justifiable reliance it can be a very heavy burden, especially in circumstances, again, I go back to the beginning of Eduardo's point in arbitration about sophisticated parties. And in that case, a justifiable reliance showing can be extremely difficult. Having said that, I do think the similarities are probably with the Venire doctrine are probably more important than the differences. And I do think estoppel, of course, is pleaded quite frequently in New York law arbitrations, in my experience. And I think that a lot of that has to do with a conception of introducing to the tribunal, even if you don't win on it, the idea that there's a fairness issue at the heart of this case, and that the tribunal should keep that in mind when it's interpreting the contract. So I will stop there, but I think it's a very interesting comparison that you raise.
Well, thank you, Larry. Thank you, Eduardo. Thank you, of course, Franco, for everything you have said today. I would like to move forward to give the floor to Franco. We're about a very limited period of time, so I'd like to give Franco the floor to close our session of today.
So thank you very much to everyone, foremost to Cristiano, who, as I mentioned on other occasions, was the mind behind the 4 webinars on contract law for arbitrators, Brazilian law, New York law, and transnational law, but also, of course, today to our colleagues, Larry and Eduardo. There's a lot more to be said. I agree with the estoppel. I think the CISG, for example, has an estoppel doctrine. It incorporates it. There are 2 provisions that, in my opinion, refer to it nearly expressly and so forth. Much more to be said, not today. Thank you to the audience for listening in. Thank you to the colleagues, and of course also to Arbitration Channel for making this possible. I hope to see you all on the 30th of May. On the 13th of May, we will have our last talk on penalty clauses. See you then. Bye to everybody and stay safe.
Bye, thank you.